I'm the only one to lead it.
Huh?
Good evening, everybody, and welcome to the zoning board meeting of December 6th. If you would please stand with us and join in the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. The Goffstown Zoning Board is an elected board of 5 members and up to 5 appointed alternates. Currently, the board has 5 members and 1 alternate, and if anybody is interested in serving on the zoning board, you can contact Town Hall Zoning Office for information. The board has a posted agenda for each meeting and tends to follow the items in order. The board will open the public hearing on an application to receive testimony from applicants, abutters, and affected parties, and to ask questions about the application. The public hearing will then be closed, and the board will enter into a deliberative session to discuss the merits of the request. For each application, the board will decide to approve with conditions, deny, or continue to a later meeting. You're welcome to watch the deliberations here this evening, or you can contact Town Hall to get the results. For an applicant's request to be approved, there must be an affirmative vote of at least 3 members, and an applicant can request a continuance if there's not a full 5-member board to act on an application. If you are aggrieved by a decision made by the ZBA tonight, you have the right to appeal to the Superior Court. However, before appealing to Superior Court, you must request a rehearing with this board to preserve your right to appeal. Rehearing requests must be filed within 30 days of the decision, and it must state all the reasons why the decision was unlawful or unreasonable. Failure to request a rehearing may forfeit your ability to appeal to Superior Court. So I'm going to ask everybody to please make sure your phones are silenced for the course of the meeting, and I'm going to ask the board to introduce themselves, and we'll start with Derek.
Derek Horn, Town Administrator.
Denise Langley, member.
Alan Yaton, member.
Leonard Stewart, Vice Chairman.
Gail LeBrecq, I'm the chair and the recording secretary.
Judy Elaine, member.
Jason Cody, member.
Jack Shepard, Building Inspector, Code Enforcement Officer.
Thank you, everybody. Our first action tonight is to approve or amend the minutes to the zoning board meeting of November 1st. Do we have a motion or corrections?
Motion to accept.
Second.
Okay, no corrections?
No.
All right. All in favor?
Aye.
Any against or abstaining? None. Motion carries. Our first application is Jennifer Purrier, owner, and Stephen Dovich, applicant, seeking a variance to replace an existing porch with an attached 2-car garage and breezeway that will encroach within the inner 50 feet of the Wetland and Surface Water Conservation District buffer. This concerns section 13.3.5 of the Goffstown zoning ordinance. The proposed addition expands upon the existing footprint by 2 feet and will be 7 feet from the designated surface water, whereas a 100-foot setback is required. The property is located at 21 Autumn Street, map 7 lot 71-1. It's zoned residential 1 and Wetland Surface Water Conservation District overlay. And welcome. Could you introduce yourselves, please?
Hi, good evening. I am Jennifer Purrier.
And I'm Stephen Dovich.
Okay, and could you tell us about your application, please?
Excuse me, Gail, do you want to take a motion on
Oh,
regional
regional impact, yes, please.
I motion to regional impact.
Second.
All in favor?
Aye.
Any against or abstaining? Okay, motion carries. I'm sorry. Tell us about your application.
So we have a porch that is added onto our current property right now that was built in 1987. Our footprint also calls for a shed that is on our property. So we would like to replace the existing footprint with a 2-car garage with a living space above. The left to right distance would be approximately 3 feet bigger than what it stands right now, and from front to back would be additional 2 feet to accommodate a standard size garage.
Okay. Any input to what she said?
The porch that we have, it's currently, it's in pretty rough shape, so it's pretty much the reason why we want to take it down, as well as to give us outdoor storage space. Right now, underneath the porch acts as our our makeshift shed. So all of our outdoor equipment and everything is out pretty much in the elements. So that's the biggest reason why we'd like to add a garage onto the house to give us some appropriate space.
Okay.
So.
Now, did you go to the Conservation Commission with
We
this
did.
application? Do we have your comments?
I don't, let me look.
I do.
Okay.
And I thought I saw it as I did the minutes to that one, but I didn't see the comments in here. If I remember correctly, they weren't opposed.
No, they did approve.
They approved it. I don't have them. I have the.
So
Oh,
I'm
actually,
I
yes.
apologize. So Patty did send this. She said, the Conservation Commission voted all in favor to recommend the granting of the variance and that the plan go forward on the basis there is no increase of negative environmental impact, and what they are adding is going to have essentially the same footprint of impermeable surface. And that's from their meeting on November 16th.
Okay. Thank you. Okay, does the board have any questions?
I do.
Denise was shaking her head first. Go ahead, Denise.
So explain to me, and I'm sorry, so you said the existing, well, the future garage is gonna have a larger footprint, but you're saying you're kind of building in the same footprint. Is that because you're using the shed, as you're removing the shed, and that square footage you're putting where the garage is going?
So right now, there's the porch, and then onto the side of the porch, there is a 6-foot wide shed. So total distance from left to right, the new structure would be 3 feet bigger than what's already there now.
Okay, so you are increasing a little bit more space.
Yes, and that is to allow for a standard size garage for 2 vehicles.
No, and
Which
that's
is a luxury.
understandable. I just needed to understand that.
If I remember correctly from when I did the minutes, they were increasing it by about 2 feet into.
Front to back.
Yeah.
Alan?
I noticed when I was at the site that our GIS map is totally inaccurate in terms of the water course. There is a brook that runs behind the house, but the GIS shows tied into it. There's nothing there. It doesn't exist.
The wetland?
No.
The what?
This portion of the brook
Oh,
That shows on the GIS.
that
Yeah.
shows on the GIS, which is probably part of the reason for being here, is that it doesn't exist.
right.
There is a culvert, small as it is, it's under Autumn Drive, but it drains their front yard. But the rest of the drainage comes from behind the house, it goes down into a wetland off of Mass Road.
Okay, good,
So it's not connected in any way.
good, that's good to know. Jason? Len?
No?
Judy?
I'll say.
Okay. Is there anything else you want to tell us about your application? No. I know your application included your comments regarding the variance criteria and how you meet it. Is there anything you want to expand on that for? You don't have to read what you've written, because it is part of the record just in written form. But if you have anything to add to it that you've thought of, then we can do that as well.
No, I think everything that we have submitted and everything that we've asked for is pretty straightforward. All the all the homes in our neighborhoods have very similar split raised ranches with additions on it, so we would, be right in line with our neighbors around us.
Okay. The board has no other questions? Ready for public comment? Okay. Is there anybody in the audience who wants to make any comments about this application? Okay, there are none. So we will close the public hearing and the board's going to deliberate on your application.
Thank you very much. We appreciate your time.
Okay. Comments, discussion?
I'm reading their application, they're building a garage, they're gonna be able to put things undercover. I agree with Alan with the wetland. Doesn't go right through like it shows on the map. It's still within the buffer, but they're pretty much following the same footprint that they have
Yeah,
existing.
the planning board agrees with what the two of you have said. I'm not the planning board, the Conservation Commission.
Anybody else have comments? Because I'll make a motion. No?
Okay, just remember, we need to have findings.
Yeah?
Okay, shoot.
Okay. Let me just get the order. Bear with me, I'm sorry. Okay, I vote that we grant the variance to replace an existing porch with an attached two-car garage and breezeway that will encroach within the 50 feet of the 100-foot wetland and surface water conservation district buffer.
Okay,
Based on the findings, not contrary. They're pretty much replacing with the same size, a little bit larger, more usable space. Follows the spirit of the ordinance, because the water really sets back a little further than it shows on the map. There's no substantial reason not to give this out. It's not going to hurt anybody, it's not going to hurt the town, it's not going to affect the values. I stopped there. Let me just, sorry. What else here? It would result in unnecessary hardship. They got a piece of property that they want to put a garage. We do live in New Hampshire.
and winter is
And
coming.
it is
And
December.
it's December. Good luck getting that built.
Do you want to add the concerns of the Conservation Commission about not increasing the negative impact?
Yes, yes, please.
Okay.
Well, that was a lot. Can you say it again?
I'll second the motion.
No.
But I also would say that their home sits the furthest back from the street of any of the street.
Okay. That's good to know. Okay, we ready to vote? All in favor?
Aye.
Any against or abstaining? None? Motion carries. You have your variance.
Thank you.
You're welcome. Our next application is, I think I missed, no, it's not. McKim Jr. Revocable Trust, James McKim Jr. Revocable Trust, owner, and Nancy Nichols, applicant, seeking a variance to build a proposed garage and breezeway attached to a single-family home that will exceed the 10% building coverage allowed per section 4.3 of the Goffstown zoning ordinance. The property is located at 25 McFarland Road, map 42, lot 60, zoned agricultural and wetland surface water conservation district overlay. And, whoa, we have a whole board over
Lots
there.
of people.
Can you introduce yourselves, please?
Coming from both sides. Good evening, I'm John Bisson,
I'm James McKim.
Nancy Nichols.
the owners of the property. And the property address, I think the chairperson said 25, it's 29. It's 29, just to make sure we're clear. 29 McFarland, which is a very small, it's a .25 acre non-conforming lot in the agricultural zone. It's improved with a cottage-style structure that...
Can I interrupt you just for a minute? We need to do a motion for regional impact.
Motion for no regional impact.
Thank you, Jason.
Second.
Sorry.
Okay, all in
I'm
favor?
busy on top.
I should have got that from both.
Thank you, motion carries. All right, now you can
Sorry.
proceed, thank you.
So it's improved with a small cottage-style home. When the folks on either side of me purchased the home a year ago, it's in rough shape and it's getting rehabilitated. And what they're trying to do, much like the folks that were here before us, is put a garage and a breezeway onto an existing structure for storage and for access that's age appropriate, so they can age into the home and single family living and all of that. So essentially putting in a new entrance to the property on the north side. The issue that brings us here is the lot coverage. Because it's a non-conforming lot, it's very small, 1/4 acre. In the agricultural zone, most lots are supposed to be 2 acres, so if it was a 2-acre lot, we wouldn't need to be here. So the coverage issue is we can't exceed 10% of the lot size, and here we do, and that's why we're here for a variance. And essentially, we're going to be improving the property by putting on a garage and a breezeway to enter into the property. Some of the improvements that will come as a result of it, they're going to be removing some surface, and so fixing the retaining wall. So as part of the improvements that they're going to do, there's going to be some removal of some impervious surface overall. So essentially the application, I think, speaks for itself in terms of what we're looking for. What they're doing is consistent with single-family homes. Their closest neighbor to us, they're here tonight, and my understanding is that they're in support of this, but I'll obviously let them speak for themselves. Essentially putting on a garage for use on a single-family home. I don't want to belabor you by going through the criteria. I appreciate that you can read the application, so certainly if there are any questions about what we put in there, I'm happy to go through them with you.
What's the percentage of coverage that it's going to be, if it's going to be over the 10%?
Do you know specifically? It's like 12?
Yeah.
It's only it's a very fractional increase over. It's like 12%. So instead of 10, it's 12.
Is it currently 10?
It is currently 10.
Okay.
Does the board have any questions? Go ahead.
Okay. Can you talk to me about a little bit about removing the impervious surface and where that is?
So if you look on the plan, and I know it's a little bit
Yeah.
fuzzy. So if you look to the lake, the front of the property on the lake corner, the sort of right-hand corner on the bottom on the lakeside, there's a hashed area or hatched area
Yes.
where it says to be removed, area to be loamed and seeded or replaced with porous pavers. Do you see that?
Yes.
So that sort of weird shaped hexagonal piece is going to go, and that's also where there's an existing retaining wall that's made of rubber tires that's not in the best of shape, that will be attended to as well. So that corner area on the front right hand of the lot is going to be removed.
And that's going to be done prior to any work being done on the house? Before you add a garage and a breezeway,
Right, that's good.
that would be done first?
Yep.
Or at the same time?
And also, the footprint of the garage is actually going to be where there is now stone dust and considered by the shoreline to be impervious as well. So
Okay.
it's going impervious right where impervious is.
Okay.
So we're actually reducing the total amount of impervious area on the site in our development plan.
You reduce it?
We're reducing it
By how much?
5%.
Oh, there's that 2%? Did they have conservation? Did they have conservation being close to the lake?
I don't recall.
So this is not a variance from the wetland setback.
So they didn't need to.
If,
If we're outside of the
Yeah, the buffer.
yes, they're outside of the 50, they will need a conditional use permit, because the way our zoning ordinance is, the closest 50 feet requires a variance, the outer 50 feet is planning board conditional use permit.
Thank you.
Anybody else have questions? Alan? Len? No. Judy?
No.
Jason?
No.
No questions. So you just need the variance because of, to exceed the amount of coverage allowed?
Correct, it would be
Okay,
10%,
not any-
going to 12.
Okay. Okay, well, with no comments, I'll open to the public. Is there anybody in the public who wants to make a comment?
Just our approval. We live next door and they've been very upfront with what they want to do, have no issues.
Can we have your names, please?
My name is Rick Kirby, Kirby. I own the property at 33 McFarland, along with my wife.
And you're in agreement as well?
Excuse?
Mrs. Kirby, you're in agreement as well? Okay.
It's good we don't want to have that issue.
Hard to sort that one out.
Could be interesting.
Okay. Is there anybody else who has any comments that they want to make? No? Okay. Then I'm going to close the public hearing and the board's going to deliberate. What's the board's druthers?
I'm glad to see they're getting rid of some impervious
Yeah, the reduction.
close to the lake,
Yeah.
cleaning it up. Nobody wants to see those rubber ties, those ties. Glad to see that, and it's 2%.
Yeah, there's the engineer. Boy, I don't know. She does it.
What'd you say?
Nothing, I was just busting her chops.
Oh, okay.
Waiting for you, Jason.
I'm good.
Oh, whoa.
I figured
That's
he'd,
2 in a row.
I figured he'd,
Yeah.
do it.
I'm trying to write things down. I'll make a motion to approve the applicant's variance for a proposed garage and breezeway attached to a single-family home exceeding the 10% building coverage at 29 McFarland Road, map 42, lot 60, finding it's not contrary to the public interest as they'll be approving the looks and an overall function with the impervious removal and whatnot. Spirit of the ordinance observed, it is a small lot compared to a lot of the others up there. So they're trying to, you know, they're close to the 10%, so they're not over exceeding. Substantial justice would be done. Again, it's going to improve the house, so there's and area. So there's really there's more detriment than there is benefit for it. They should have no value, property value change, and if the order was enforced, then they wouldn't be able to do what they need to do.
You said there's more detriment?
Yeah,
There would,
You mean there's more improvement?
there's more improvement.
Did you have it backwards?
there's more improvement than there would be detriment
Okay.
to the
You
town.
had- you had it backwards, I think.
That's possible
Could we just add that
with
they
approval.
need to add to the end result has to be
Yeah.
less impervious than they currently have?
The what, oh, the end result?
Yes.
Yeah.
That 5% minimum, less than
Well, I'm not gonna give a percentage in
Okay.
case it's not perfect,
Right,
but
less,
as they stated here, they're gonna remove the impervious
okay.
at the front. I call it the front, but at the lakeside.
Okay. Do we have a second?
I'll second.
All in favor?
Aye.
Aye. Okay, motion carries 5-0-0.
Thank you. Well, I was looking for members, just keep that in mind.
I don't live in Goffstown, but do you?
Exactly, if anybody's sitting out there.
Our next application is Hemley Investments LLC owners applicants. They're seeking 2 variances to develop a lot with no frontage. This concerns sections 4.2.1 and 4.3 of the Goffstown zoning ordinance. The applicant is also requesting an appeal from an administrative decision, appealing the planning board's decision to not accept the site plan application as complete due to the lot lacking the frontage. This concerns section 4.2.1 and 4.3 of the Goffstown zoning ordinances. The properties are located at 134 Mast Road and Tatro Drive, map 5, lots 54 and 54-1, zoned commercial industrial flex zone. I'm going to entertain a motion for regional impact.
Motion of regional impact.
Second.
Jason, Alan, all in favor?
Aye.
And Denise has recused herself, I'm assuming?
Yes, she has.
There she is. I'm going to also be recusing myself, and I'm going to appoint Judy Elaine as a voting alternate as soon as I finish writing. And Len Stewart, our chair, is going to take over the meeting. Okay? You all set?
As all set as I'm going to be. Since we do not have a full board tonight, I'm going to address Attorney Cronin, correct?
Attorney Muller.
Attorney Muller, my apologies.
No, not a problem.
But do you wish, given the option that we do not have a full board tonight, to proceed with it?
I have spoken to my client. We are going to proceed because I believe in this particular case we're going to run into the same circumstance again and again. It's not a situation where you have, could or will likely have more board members going forward. So we are simply going to proceed because I think, again, it's, history will simply repeat itself if we continue it.
All right, and I will put this to the consensus of the board. I think it would be most appropriate before considering the variances to consider the appellate part of your proceeding and to, it just seems to me to be the threshold point that if that, depending on the outcome of that, the variances might be moot. So
That's agreeable to us. And I guess I have one point of clarification that I sort of have to raise beforehand. Obviously, the board knows this is not my first time here on this property or relative to this development. We were here back in October, well, back here in 2020 for the use and for the setback. That was initially denied. We went up to the Housing Appeals Board. They issued a decision in this case. It got remanded. And I guess one of the initial procedural questions I'll have to raise, we've had 2 recusals, and I understand the effect that has on the board. During the remand, member Yeaton also recused himself at the last hearing. I don't believe I remember a reason for it. But if it's something that would impact his impartiality here, again, I don't know why he did so. It was at the second meeting, and the board actually voted to grant the relief on the remand. But if the same issues arise, then I would have to ask for a disqualification there, because obviously there was something at that meeting and there was something that occurred that led him to do it. I can't speak as to what it is, but I do have to raise that issue, because I generally assume that people raise it one time, they have a good reason for doing so.
understood, and or as you understand that the decision to recuse or not recuse is up to the individual members. Oh, if Alan wishes to sit on this case, we would have to accept him as a voting member of the board for this case. Alan, what's your pleasure on this after
I'm gonna
the...
sit here.
All right.
Okay, as I said, I just, given the circumstances beforehand, had to raise that. I do appreciate the board addressing that. I will start with the administrative appeal, and I'm gonna, there's a lot in there. There's some stuff that I will freely admit I don't think is really for this board. I do it to preserve any issues for the future, if need be. The hope obviously is not. We are here in part on an appeal from the planning board pursuant to RSA 676(5) Roman 3. The planning board determined that the property in question lacked frontage, and therefore a variance was required. I'm going to focus on two general areas tonight, because again, your jurisdiction is usually focused on the issue of whether they correctly construed and applied the zoning ordinance or not. And the principal argument here is that they misconstrued the notion of what was a lot of record. And it does take a little bit of background to sort of explain why that is. But if you look at their findings of fact they made in this case, a lot of what they focused on was a change in how the property was assessed in 2013. Number one, as a legal matter, how the property is assessed is not dispositive of how it is treated for land use purposes. That's black letter law at this point in time. I cited a case that, one of the earlier cases, Robillard versus the town of Hudson, which established that. It has been repeated by the Supreme Court again and again. But the suggestion here is that in 2013, the assessor sort of looked back at things and corrected how it was being assessed. As opposed to one lot, it was two. And they say that that sort of somehow bore on the issue of what the lot of record was. I disagree for a number of reasons. A, the property in its current configuration has existed in its current configuration since at least 1952. In that year, a gentleman by the name of Papacalos bought what is the third tract. He had already acquired two of the tracts. The deed deeds to the property since 87 have referenced 3 tracts, not 2, which undermines some of the rationale in terms of the finding facts of the planning board. But the reality is, according to the assessing records, a single-family house was built on this property in 1950. By 1952, all 3 of the parcels in the deed were all together. This predated your zoning ordinance by about 9 years. So it was a pre-existing non-conforming lot of record to the extent it didn't comply with what came into effect in 1961. The access to the single-family home. The single-family home was located, in fact, technically still is located on what is called the back piece of the property. And the notion that this property has a front piece and a back piece actually dates back to when the owners in the late 1840s conveyed, or in my view, leased the railroad right-of-way in the first instance, because there was an award given, and that award at the end talks about, and their name was Brown, and it talks about essentially the upper and lower pieces of the land taken from said Brown. So there was this railroad right-of-way, which was, in my view, because it was articles of agreement, it was not a deed, split up what had been a farmland back in the late 1840s. Admittedly, the property stayed in common ownership for a while, then broke out, but back in 1952 came all back in common ownership, and from that date forward, the entirety of the 3 lots were used as a single lot. The town, notwithstanding the 2013 action, had actually recognized this on several occasions. In 1986, it acquired a sewer easement from the then owner of all 3 parcels, Mr. Papacalos. That sewer easement was in what is now recognized to be the railroad right-of-way, i.e. the town treated him not only as the owner of the land around it, but actually of the railroad right-of-way itself back in 1986. The town also got a right to pass and repass to get to that sewer easement from Mr. Papacalos, which was over his, said to encumber one lot, which was at the time lot 54. Didn't describe it as over this parcel and over this parcel, it was over one lot. Starting in the 2000s, there were actually several applications to various boards in this town to develop this property. Not once was the issue of frontage raised. That included a site plan application for a office building and assorted non-residential uses. There was at least an abbreviated application for a similar residential use to what has been since approved by this board. While that application was ultimately denied because it was not pursued, again, when they applied for the relief, no frontage relief was required. It was recognized that this property, which again, since 1952 had been viewed as a single lot, had been used as a single lot where you went from Mass Road, you drove over the front portion, over the railroad right-of-way, over a crossing that had been in existence since 1849, to the house in the back. Enforcement actions had been taken against prior owners back in the 1990s. They only spoke of one lot. Again, one lot again and again because that's how it was used. And how you use a lot, notwithstanding the deed description, can create a single lot for land use purposes. As I indicate in my application, I'm not sure that if the roles were reversed and my client was looking to say the front lot was a separate lot, given the historical use, that the town would have said, no, you don't need subdivision approval, you can just go ahead and use it as a non-conforming lot. So at the end of the day here, and the case that basically controls this is that Rob Allard case I mentioned earlier. The law to record is all three together because that's how they've been used for almost 70 years, up until this case. And the other sort of issue here that I think at least arguably goes to matters within your jurisdiction is, as I indicated earlier, this is not our first trip here. We came here, we filed in October 2020. Notwithstanding these findings of fact, the findings of fact from the planning board sort of suggest that this issue was first raised after the proceedings before this board were done. That's not accurate. I had a discussion at the time of the initial filing with Ms. Duffy, who did raise the frontage issue. I raised objections. Nobody said, you gotta put that on hold because we gotta take a look at this. You may need frontage relief as well. We were allowed to go forward. There was a staff report that was issued relative to that first variance application back in 2020. Did not say that frontage relief was required. And I would note that there's a constitutional duty here that the town has. Tell my client whether procedurally and substantively his application is in order. So, basic notion here, if there is to be a frontage issue that was to be raised, it should have been raised back during the initial proceedings, not 2 years after the fact. Because obviously, this now delays any further proceedings on this matter. We've already been before this board once And it's not the best use of resources of time for anybody. And you can violate your duty if you essentially do something that causes an unreasonable delay. That's my reading of the law under the Richmond versus City of Concord case, that you just can't wait and sort of surprise people after the fact. Again, the issue was raised. I understood that my objections were heard, and there was nothing further at that point, and that's when it should have occurred. Third point, which I'll just touch on because I think it just deserves a little bit of attention here, and I understand that property and real estate title is not your area. Understand that. I don't think it was the planning board's area either. And I think the first argument, just so it's clear, applies regardless of who has title to the railroad right away, because that has been the issue. Now, I will note that when we went up the first time to the Housing Appeals Board, there was some discussion on title to the railroad right away. And the Housing Appeals Board noted that while we presented the basis for arguing that we had title to it, i.e. we were the owners, including the fact that the town had previously sought an easement from my client over that railroad right away, something that's not consistent with the notion that you own it, because an owner cannot have an easement over their own property. They noted that the town did dispute, but also noted that it presented nothing to support its claim. And so you have a board that sort of already looked at it, sort of already suggested that only one side presented anything relative to their ownership. There was an objection, but there was no substantive showing as to why they would have had title. And this now goes to the sort of the findings of facts in this case. If you look at the record from the planning board, town records were corrected in 2013 by creating new law 54-1. I understand that that was the finding of fact made. Not sure there was any evidence to that effect. Now, a lot of this was just stuff that was drafted up in preparation without any evidence going one way or the other. Now, frankly, some of this stuff is something that they would have notice of because there was zone proceedings. But at the end of the day, I do have to sort of end this by calling attention to finding of fact number 10. The planning board is not aware of any express findings of the property did not require frontage. As I indicated, you had a duty to raise it if it did. Constitutional duty. This isn't something that's in any statute or anything. This is a constitutional duty. It's called the duty of assistance. And it's something that all municipalities own to all of their residents and all those who are applying to use their land before them. I noted to the planning board, and I will note it here, if I came to buy this property prior to this case, and I came down to town hall, which is what every town wants you to do, and I looked at your records and said, I want to buy this property for development. Well, I see zoning board decisions, planning board decisions, all considering relief where no frontage requirement was put forth. There's nothing saying I had to get relief from the frontage. So as a buyer, member of the public, who's done their due diligence, which is what everybody wants to have happen, if I came down here, I'd have no idea that the town was suddenly going to change their position after apparently decades, that suddenly this was, nope, you no longer have frontage on Mass Road, even though you've been using it as a single lot for 70 years, we've granted all these approvals, or acted on all these approvals, or considered all these approvals without requiring it, we're now going to require it. Not to mention in this case, waiting 2 years to do it after the fact. So based on all of those things, again, I think the lot of record is something that the planning board erred on. The lot of record here is all 3 parcels, because that's what has been used and treated as a single lot, including by the town, for 70+ years. And we would ask that the board find that there is an error in that regard and reverse the planning board's determination that there was no frontage. If the board has any questions, I'd be happy to answer them.
No, let me go around. Alan? Jason?
Not right now.
Not at this time.
I'm going to ask one of my own, because after reading this very carefully, the crux of the argument seems to come down to the lot of record, and it seems that from what I'm hearing, your position, if there is a long-term adverse usage here, that this indeed trumps the fact that the town is claiming a deeded right to that 54-1, the rail trail parcel that separates the front and the back portions of the property. It seems to me as a layman that it comes down to a question of title.
Let me clarify, because I was trying to minimize the title issue, because that, as I said, there is a case called Short versus the Town of Rye, which basically says those sorts of private property issues are not for land use boards. I'll try to clarify, regardless of who owns it, that strip there. Let's just assume the town owns it, okay? We'll assume for purposes here that the town owns it. The property to the front and back have been used as a single development since the property had been together in 1952. It was developed for single-family purposes. The driveway, which serves the house in the back, goes across that front piece. 54-1 Mass Road, there's a driveway, goes up there. That's how you get to that property. It's been used as a single thing. And the Robillard case basically says if you intentionally sort of disregard deed descriptions and you sort of use something as one, there are some later cases, Roberts versus Town of Wyndham is another one that stands for a similar proposition. You, by treating something as a single lot, you can say to have voluntarily merged them into one. And that's what we're saying has occurred here. It's been used as one single lot, notwithstanding the former railroad right-of-way. And, you know, obviously if we own the railroad right-of-way, they're titled to it, then the whole thing goes away. And I'd like, you know, be great to be able to say that, but I know that's not an issue for this board to decide. And unfortunately, I think the planning board did that as too, but that's an issue for somebody else. But I'm saying, forget the whole title issue. How has this property been used for all this time? You know, the whole thing here for the planning board is, oh, in 2013, the assessor goes in and takes a look and says, well, I think I'm going to treat it for assessing purposes as 2 lots. Well, as I said, legally, I think that's irrelevant, because it's not dispositive of how it's been treated for land use purposes, and that's the law. And I said, factually, the people there have been going back and forth across that front piece, have put a driveway, access to the house in the back, and so it's been used as a single lot since 1952, which again predated your zoning ordinance by about 9 years. So I think that's, from a layman's standpoint, this has been used as one lot, and therefore it should be continued to be treated as one lot. And as I said, I just simply think the fact that the town has repeatedly done so bolsters that argument. When it has come before them previously for development purposes, no one has suggested that frontage has been a problem. And what is now 54 has been part of those prior developments. There's been development proposed on that prior 54. No one said a thing up until this case. And to me, if the only change between the time of those cases and this one is that 2013 change by the assessor, that's not a material change under the Robillard case. So, I hope that clarifies it a little bit.
Somewhat, thank you. Anyone else? Members of the board? Don't everybody talk at once.
The past variances that were granted for this, weren't they, but not the ones from, I'm still trying to go back and find when the original thing was presented, but,
Which were, for this case?
no, so previous to this case, that was, for this setup, that was,
Commercial lot?
yeah, so I guess prior to before I was on this board, there were
Yes.
there were cases for this.
Yep.
That, as I understand it, there were variances approved for commercial development of this property. Is that true?
Let's see.
There were none.
No, March 9, 2004, Brookfield Investment obtained a variance for a business and professional office building on the property. The only relief required for the proposed development was then section 3.10D6, which was for the use. So that was March 9, 2004.
Okay. So that was a commercial proposal then.
And in terms of the planning board, January 11th, 2007, they approved the site plan for a two-story office and warehouse on the property. There was no frontage required for, relief required for that proposal either.
Okay, thank you.
I would note that I was a member of the planning board at that time and voted for that project.
That's the only question I have right now, Lynn.
Alan, Judy, anything else?
No.
I would say that right away, all the way from town here to Manchester causes umpteen problems all the way in and out over time.
Although I would offer a counterpoint to what you're saying, there have been a number of other projects successfully developed along that right of way, and we'll leave it at that.
Yep. Well, we had one recently with the trailer across from where the new car wash is. the fact that there existed a right-of-way which they were gonna use to develop that across the rail trail.
Mm.
So there's instances both pro and con all the way up and down. I think it might have been somebody's wisdom to create 3 lots. Somebody in assessing did that. It wasn't somebody that, an owner that requested that happen.
When,
And quite possibly, they did never questioned the fact that it happened. They just got a tax bill. I bet they've still got just one tax bill. Did you get one tax bill or 2?
Starting in 2013, you got 2.
Okay. Up until that time, they got one tax bill. So the town considered it one parcel. Up until 2013. What happened then? Nobody has any idea of why or who was responsible for it. Because it was an approved site plan for development of that property that existed with access across it, and it was, at that time, it was considered one site, one lot.
So, I guess my question goes to, at what point did it, when you have a map, like a lot, and then like, so like, let's say it's lot 10, and then there's a lot 10 and 10-1, that's because of a subdivision, correct?
Typically, I will say I do have access to the assessing file, and there's a memo to the file from Scott Bartlett, who is the town assessor, dated June 3rd, 2013. It references many of the deeds, notes on different plans. But what it says in the first sentence, for the 2013 tax year, I created map 5, lot 54-1 for taxation purposes.
So up until that time, it was one lot. And someone took it upon themselves to make it 2.
Attorney Mueller?
I'll just simply add, because just so that the board is aware, this is not a completely unusual issue. It may not happen here, but I can tell you I do a lot of work in the city of Manchester. And what frequently happens is that you will see the tax map shows you 3 lots. You go in for a building permit, and the zoning enforcement officer will say, well, there is a shed on this tax map that is attached to the house on this different tax map, so for zoning purposes, we consider it all one lot. That happens fairly frequently.
Yeah, but in Goffstown, we've had that happen, and we've treated them as 2 separate zone pieces. Like I'm thinking the one last time where we had agricultural and commercial.
So that's split zoning, which is a little bit different.
Different thing.
And again, as I said, the case law is clear that he split it for tax purposes. You can do that. It doesn't change it because, for example, the only body that I'm aware of under the state law that can subdivide a property, go from 1 land use lot to 2, would be the planning board. You'd have to have a subdivision approval for that sort of thing. So that's, again, part of the reason why that the Supreme Court, when they looked at the issue, said it's all interesting, how you tax it, but that doesn't bear on how it is dealt with from a land use perspective. And maybe Rob Millard, what basically happened in that case, just to give an example, they had 2 tax lots. 2 separate lots, they were actually separately described in the deed. They built their house so it actually crossed over the line, and then went to, I believe in that case, convey one of the lots. And the town said, no, that's one parcel now because you built over the line. You've used both tax lots as one development. And the Supreme Court upheld that determination, saying that by intentionally using it as a single development, you had changed that to one lot for land use purposes.
The thing I am having trouble wrapping my head around on this is the issue of, you make strong arguments for the historical use of the property as one, but legally how a lot that is treated separately on town and tax maps is able to confer its frontage on something that is a separate lot. And granting and understanding your presentations regarding the historical use of the lot, just as a layman, I have trouble how we transfer frontage from one parcel to another when they're both legally defined.
The same way that you would, we'll go back to the Rob Millard case. I could have, let's say I have 5 lots, we'll even go higher, 5 of them, separately describing the deed. And one of my predecessors in title decides that, you know something, I'm gonna put a house on this lot, gonna have a driveway that goes over these 2 lots, gonna have a shed on this lot, driveway on this lot, all separate lots. And we'll say, we'll take the thing here, only one lot, the very lot in the front where the driveway, one of the 2 that the driveway goes over, is on a road. They would say that those had been made through the use into one land use lot. And if you wanted to split them up, you would have to go to the planning board for subdivision approval. Because that's how they had been purposely used for a period of time. This isn't the mistake type situation, this is, and that's not what happened here. The crossing over the railroad right-of-way was initially reserved back in 1849 because the Browns, who owned both sides at the time, wanted to get back and forth to their land. That right continues, it continues to the current day. It was confirmed back in 1948 at the Boston, Maine, when I believe it was Miss Alba was looking to buy the properties with a clear intention of developing them, because the house comes on in 1950, so it appears that she was making sure that she could get from Mass Road, if they built a house beyond the railroad right away at the time, could get there. Therefore, the intention was, I'm using this area as one thing, and that, again, the current configuration of the lot, including the driveway to the house, all 3 parcels have been together since '52. Now, and they've been treated as a single lot for land use purposes up until this case as a single lot. Again, not the first time this was before the board. or before the planning board. Now, it's been used as one lot, and that's all we're asking for, is that it be, continue to be recognized how it's been used all this time. Not looking for anything else, and I realize that, if it were different, if if it were different, and I was, again, looking to split them up, I have a feeling I would be coming, the conclusion would have been the opposite, that it's one that I need subdivision approval here. But, again, I understand from a conceptual standpoint, and I guess part of the thing was, I'm sorry, you could draw in there if you want, but if I have say the initial Brown property was like a big square, and I lease this portion right through towards the bottom. That's what happened back in the 1840s. It was a lease. It still doesn't change the fact that, this was taken, this little strip for right-of-way was taken from a larger parcel that was considered one lot. And that's, again, they all went back together, that's how they did it.
Alan?
You need to read the definition of frontage in that zoning ordinance.
Okay, would you like to give us a dramatic reading?
No.
What page you want, Alan?
Roman numeral 7.
Roman numeral 7. The front lot, by the definition in here, obviously has frontage as it's defined here. Now, if you look up RSA 230-44, is that gonna lead us somewhere? Not in here, I don't think. 230-44. I don't even find it.
It's a definition of state of limited access highways. I don't believe that would apply in this location.
So, the answer to the question would be, if it has frontage on Mass Road, and you consider it as one lot, then there's no reason to not grant a variance. This application.
We're not looking at a variance right now, we're just looking at an appeal.
This is on the appeal from the administrative decision.
Who made the administrative decision?
The planning board did.
The planning
They
board, this is on an
determined,
appeal.
they determined the
From the
project does
planning.
not have
All right,
frontage.
okay. Well, do we have any supporting data from the minutes of the planning board?
You have in your packet, you have the notice of decision near the back from the October 27th meeting. And there are 10 finding of facts that Attorney Mueller spoke to earlier. So it's, I think, 3 or 4 from the back. So they voted to find the application incomplete, finding that it lacks frontage.
Okay, but if you look at page 16,
Of what?
the package on this particular one, look at page 16 of the, it has Roman numeral 16. And that's a notice of decision where the chairman made a motion to, with conditions. And I don't see anything in there with conditions about the fact that, that there's any requirement for, or supposition about right-of-ways or frontage on lots.
So just to
It
be
was assumed
clear,
that- It was assumed at that time that the lot had frontage.
so I think what Alan is referring to is there is an excerpt from the meeting of January 11th, 2007 in your packet.
Mhm.
That goes on to the next page, so those are an excerpt from those meeting minutes.
It's, in my mind, there's recognition of the fact that it's one lot. It meets the required frontage, because frontage hasn't changed in the zoning ordinance. Nor is the definition for frontage.
So, point one of their decision, this is what I was remembering seeing. So, point one of the planning board decision is that there's 2 lots of record separately defined conveying 3 tracts of land. And the parcels are separate. That's what they're saying.
Separated by the rail trail.
Oh.
Not separate parcels, separated by the rail trail.
I guess I would say as a layman, looking at this, if I was going to buy this, I would see a 54-1, a 54, or a 54 and a 54 as one as 2 different things. Like, that's how I would see it. I'm like, okay, I got 2 different pieces of land here. So in this particular thing, we're saying, well, okay, one does have frontage, one doesn't. And the part that you're going to build on, right, is the one that doesn't, because you're not going to use the front one because of the whole rail trail argument, which we won't rehash because that's not the point I'm trying to make.
The condo buildings themselves would be on the back portion. whether you would use the front portion for, again, since this was sort of stopped before the process started, whether they'd want access from Mass Road to go up the back in addition to Tatro Drive. At least there was at least a hint of that at the planning board in the limited discussion we had. So to say that there'd be no development on the front parcel and that wouldn't be incorporated into the back, I think that's premature to say. I will say that the plan did not show that at this point. But again, whether it would be part of the development, it'd be part of the common land, it was going to be a condominium. So it would be part and parcel of the land that was submitted to the condominium. So it would be part of the development, regardless of the thing. And again, now, assessing designations, the person who does land use don't mean a whole lot. Because how you use the property can overcome it each and every time. So.
But part of the argument for this to begin with for the project,
yeah,
was that one of the things that made this separate is that we really couldn't do anything with the property right because of the rail trail interruption. So we used the rail trail interruption as a reason to get the other one. Now we're trying to use it to, as it itself now is a difficult reason to do this.
I don't see that they're necessarily inconsistent. Rail trail heads there. Obviously, it's not in the town's interest to have, is involved in another one near the rail trail further up by the villa.
Mm-hmm.
And there was a setback issue from the rail trail there. And there was a concern about the view from the rail trail. So obviously, there is a development concern if you put too much development in close proximity to the rail trail. That's just the reality. So, given the way the rail trail splits, what in our view has been used as one lot, yes, that makes it so it's more likely you're going to have to push it to the back because there isn't as much room up front for structures. It doesn't say that there wouldn't be anything in terms of structures. There could be roads. Again, don't know, it's premature, but the planning board may want emergency vehicle access from Mass Road, or they may want some type of limited access for residents. I don't know, we never got to that, but that's a possibility, emergency vehicle access from Mass Road.
That's a function of the planning board, right?
Correct. No question is it. The planning board is currently saying we have to get a variance from you for frontage, and then have to go to the Board of Selectmen for relief under 674-41. So there are two steps. Our argument is, no, we should be able to go to you, planning board, right now, because historically this has been used as one parcel, and nothing has changed. Okay, this notion about, we'll take finding one. The plan shows 2 lots of record separately defined in the quitclaim deed. That's, well, there's an internal inconsistency, because the plan, the deed actually has 3 tracts in it, not 2.
Right, and it says that here.
Yeah, but it says there are two lots of record. That's not true. Those 3 lots have been together since '52. There have been deeds describing all 3 lots since '87. So this wasn't something new in 2013. 1987, when Mr. Papacalos conveyed the property out to a King Trust, the deed was exactly the same as it is now. And again, that didn't stop when this came to the board in 2004 or to the planning board in 2007 from saying you have frontage because this is being used as one deed. And that's basically my primary point, that all we're looking for is to say this is the way it has been, we're asking you to continue it because that's how it's been used for all this time. And the town has recognized that, and this tries to avoid the whole title argument, because Obviously, I have an opinion on title. I understand from town council, they have a different opinion on title. We've discussed it, and I understand that. So I'm trying to avoid that issue in part because I know it's something that's outside the sports venue anyway. It's not something that you decide. So that's why the focus here is, this is the way it's been, and we're asking you to continue that because the only thing that the planning board points to is that 2013 change to the assessing records. And as I've said, legally, that's not relevant. It's relevant for taxation, I get 2 bills instead of 1, but for land use purposes, doesn't do anything, because essentially that would have said back in 2013 that the house was now no longer had frontage on anything, because the house is there. There's a single family house, there has been, since the 50s. And then its driveway is on a separate parcel. Even though, obviously, most of us would, if we build a driveway to the house, we consider that part and parcel of our land, and what we're using for is a single lot, as opposed to 2 lots. I don't think anyone who would have driven by would have thought that that was 2 lots, based on that. But again, why you do things for assessing purposes, that's what the assessor decide. Frankly, it doesn't change the analysis for me one way or the other.
Let me pose this question. Looking at point 4 of the planning board's findings in this case, what was done to address the issue in January 2021 when the planning board notes that that question of the split lots was raised at that point?
Point 4 is interesting because point 4 sort of stirs up a nest of hornets because one of the issues in the prior Housing Appeals Board case was the whole, let's send it to the planning board to comment on a variance because it sets up issues of potential partiality, potential prejudgment, and the Housing Appeals Board said that that really should not have happened. Factually, did somebody, when it went to the planning board, I think there was a comment on their record. However, from my perspective, that issue should have been raised prior to the first application coming to this board. Now it should have been raised, should have been determined. If we were told we had to get frontage, we should have been told that we needed frontage relief when we applied in October of 2020. Not after the fact and not a couple years after the fact. And the fact, my memory of the comment was more of a disagreement with the title issue. But that's just my memory of the comment. That somebody who was involved in the trails program in the town, simply disagreed that they did not have title to it given the 2004 release deed from the Boston Main Railroad.
That was zoning in October 2020?
October of 2020, we applied to this board for variances for the use and for setback. That was the case that...
I wasn't on the board then, so I'm looking back
Yeah,
at those
no, I
minutes.
think, if my memory serves me correct, when we went up, it was initially denied, we went up to the Housing Appeals Board. They reversed and remanded. I believe you may have been here for the remand.
Yeah, but that was 21.
The remand was from 21. The original filing for the zoning application, The original variance
Oh.
application was filed in October 2020.
So then that would have been heard at the November meeting.
Did you have a specific question, Jason?
Well, I'm trying to understand. No, I don't have a specific question yet. There was something I was looking for, and now that I've been distracted from that mission, which was my own fault, so I can't blame anyone.
Alan?
I just have to thumb through the application. The application is for both a variance and a special exception. So are we choosing which one we want to do?
No, this is the
No,
appeal.
This is an appeal from an administrative
appeal
decision.
From the decision of the
Why
planning.
does the packet say variance? Request for a variance.
Because that's alternative relief. If the board denies the administrative appeal, then we would ask for the variance.
Okay. So if we grant the variance, you're good, in your opinion?
We're, again,
I
we're not
asked
at that
Attorney Muller a
point, we're
question.
still on the appeal.
Obviously, my preference would be the administrative appeal be granted, because it also eliminates the issue of having to go to the Board of Selectmen under 674-41. Because if it's determined that this is a single lot, and there has no one questions that there is frontage for 54-1, if 54 and 54-1 are one lot, and 54-1 has frontage on Mass Road, then 674-41 also would not apply. And so it would eliminate that. So there is a preference for finding the administrative appeal be granted, that no relief was required in the first instance, because it eliminates both of the issues.
Okay, thank you.
Any further thoughts? Where would anyone like to venture a motion?
Can I make a suggestion that you ask if anyone from the public would like to, this is a public hearing.
Okay. With that, I see a hand in the back. Would you come on up and identify yourself? And
I might be coming up too soon, actually, because that's for the variance. If you get to a variance, then I'd like to speak.
all right, very good. Is there anyone who wishes to speak on the administrative appeal portion of the proceeding? Seeing no one, I'll declare the public hearing closed.
Will we be closing, oh, the public hearing's closed,
Well,
okay.
the board will, we can now move into deliberations.
So, the land use thing is what I keep going back and forth with. So, previously for this, we were looking at, like, we were asked to, when the van came back, right? We had to look at the entire zone, including all of the lots on the zone, as part of the CIFZ, so that they could have residential only in that space.
Correct.
But now we're being asked to look at it as one. Like, That's the part I'm having a trouble with. We can't do it both ways. It either all has to be separate or it all has to be together. That's the problem I'm having with this. Is that I can't fathom being asked to separate it for one discussion, but then put it back together for another. So I don't think I could support the appeal, because I think we have to treat them separate.
And I reluctantly, I might add, because when this case came back on remand, I felt that we had no alternative but to pass it, given the directives of the Housing Appeals Board. I think that Attorney Mueller makes a strong case that if this is the historical usage of it and the various points of case law that are cited in it, I find it hard to figure how we can do anything else except to treat it as functionally as a single lot. I do have trouble wrapping my head around how the fact you can confer frontage from one lot that is entirely, taking his example, various lots physically connected. Here you've got a front lot that is completely physically separated from the back portion of the lot, but you're conferring the frontage across another deeded lot. So,
And
yeah, I'm of two minds on this issue.
Well, and that goes back to the same problem that I brought up before, which is if we're looking at this all as one, all of these lots as one space, now the Langley lot side of it can't ever be changed to residential because, well, it could, I suppose, with variances and stuff, but now the CIFZ is disrupted because that's where the commercial part is. So she can't change it.
I just want to make sure you're clear, there's no discussion of use. This is a discussion of whether or not the planning board erred when they found this lot had frontage or not. They did not make.
Right, but we had to put all of these lots together in order for this to move forward. That's the point that I was making. So
I don't understand.
In order for, by the remand from the housing board, they said that for the purpose of the CIFZ, we would look at that whole thing as a zone. So the commercial part of the development was the Langley lot, and the residential side of the development was going to be what they're doing. That's how we're supposed to look at it. So we have to look at the whole thing together. So when we're looking at this particular property now, which is those two lots, we should be looking at them together. Maybe I just made my own argument. I think I did. I think that was the piece I was missing. Yeah. I'm gonna make a motion. I'm gonna make a motion to grant the appeal from the administrative decision of a planning board because we are supposed to be looking at that lot together because of what the remand from the Housing Appeals Board said. They're part of the CIFZ that we're dealing with is the residential, and that development is one part, one parcel. So I think that's the reason that we have to do it that way.
It seems a bit it seems like we're mixing apples and oranges by conflating the CIFZ piece of it with the lot line issue. I think that
Well, but for that decision, we had to look at this parcel, which was how they presented it to us for development as a single lot. And that's how at least when I voted on that previous one, that's how I was looking at it. So because of that, I am seeing it as a single lot. That's my motion, is because we previously, or I previously saw it as a single lot, that justifies us of granting the appeal.
Comments, anyone? Alan?
Well, just a common note here, that note 8 from the planning board. The planning board continues to recommend the applicant seek relief from the ZBA for lack of frontage for lot 54, and therefore finds the application incomplete. So that argument that you know, is confusing in itself, but and then the last one, the planning board is not aware of any express findings that the property didn't require frontage, which means they're saying the lot does require frontage, so it's up to us to determine that the front lot is the frontage lot and is part of the project, and to grant the appeal. Because in my way of thinking, he's gonna put a driveway out there, he may put deceleration lanes, he may put signage out there, so it becomes part of the project. Physically becomes part of the project too.
Are you seconding Jason's motion?
Yes, I am.
Or- All right, we have a motion on the floor.
He may
Any-
have said it better, but that was,
Well, I'm sure our recording secretary will
Gonna love
clean
this.
it up on the
Yes.
DVD. As I say, I'm reluctant on this, but I do think that the historical case that's made for the usage of it makes it hard to, you know, to think of it as two separate lots. If it's, you know, if you're talking about a right and with an established driveway across the rail trail that has been in place for, well, I've lived in town for 30 years, Alan's been here much longer, and it's probably been that way forever. Yeah, I reluctantly feel the same way. All right, we have a motion made by Jason, seconded by Alan. All in favor?
Aye.
Aye.
Thank you very much.
You're very welcome.
Procedurally, can I just add, do you want to withdraw the application, or should I just have them deny without prejudice?
I probably deny without prejudice and just,
Okay.
and on the grounds of mootness.
Okay. Yes, would you mind taking a motion to find the requested variance is no longer required, so you'll deny it without prejudice?
so moved.
Second?
All in favor?
Aye.
Aye.
Thank you once again. Have a good evening.
Wow. I can close like 6 tabs now.
We're still on.
Dare take a break.
Oh, I think it's too late.
Oh, man. I had all that water. No.
Our next application, First Sign Corporate Image Incorporated, applicant and West Keene Street LLC owner are seeking a variance to allow an internally illuminated sign that will be approximately 195 feet from the residential 2 district, whereas a 250-foot setback from a residential district is required for section 6.6.3 of the Goffstown zoning ordinance. A variance allowing a portion of the existing freestanding sign to be internally illuminated was approved by the ZBA, in 2019. The property is located at 558 Mast Road, map 3, lot 37, zone commercial. I'll entertain a motion for regional impact, please.
I'll motion there's no regional impact.
Second.
All in favor?
Aye.
Aye. Motion carries. And you want to introduce yourself, please?
My name is Scott Alberton, I'm here representing CMC in this procedure.
Scott,
And,
could you tell me your last name?
sure, Auberton, A-U-B-E-R-T-I-N.
Okay. And you're representing CMC?
Correct.
Okay.
Just a little bit of history, so we have a sign permit for the sign that's installed on this location at this time. It was a non-illuminated sign maximizing the amount of square footage that we're allowed here. And it was added to the urgent care sign 2 years ago now, I believe, just about 2 years ago. And what we're looking for is the option to internally illuminate it so that it'll be similar to the one that's there now. As you heard, you have the variance for that in place. I don't think I probably need to go into too much detail on this. There is kind of a precedent set, although I understand that precedents aren't set by variances. But it is the same exact situation. It was approved by the board previously to internally illuminate that other sign. It is on the opposite side of the property from the residential, facing Mast Road, and is in good company with a lot of other internally illuminated signs right in the area there.
Okay. Does the board have any questions?
Are we running up against a total square footage limit of signage on this property?
The freestanding sign at this point, if my memory serves me correctly, maxes out.
It does, that's
It maxes out the use of what is allowed for freestanding. And all the other signage on the property has been properly permitted.
So they're maxed out, so does he need an added variance?
No, I'm saying the urgent care that was previously allowed to be internally illuminated, as well as the CMC that they added within the last year or two.
Okay.
That is the max footprint, or the square footage for the sign. The bottom portion is not illuminated.
Okay.
And we do have permits in place for all the signs on the building, and they are within the square footage allowable. And that's actually part of the packet, I believe, that we put together, showing what the square footage is on each one of the signs.
And other than just turning the bottom light on, that's really all you're looking for. You're not going to change the sign. There's not going to be blinking things. Okay.
Okay, so you're not putting in a new sign?
Nope,
You're
the
just-
sign is already there, it is already permitted.
Okay. I get it now. For the outpatient physical therapy. I should disclose, I have a family member who works there.
Okay. I don't think that would be an issue with that.
She works in a pain clinic?
She works at urgent care, outpatient physical therapy.
I have a question. So I kind of tried to roughly do it on the GIS map. Do you know how many feet the sign is to the actual residential building?
190, to the actual building, no, to the property. 'Cause
It's
I believe the ordinance.
You do that, it's pretty, it's quite a bit.
Yeah.
It's
It's over
the
200 feet, I
building's
believe.
pretty much around the corner
Yeah.
somewhat from,
Staff estimated that it was about 195 feet
To the district.
to the district. The distance from the sign.
I'll find it. I'll find it. So I'm pulling up Google Earth right now.
He's doing it with the little,
Probably 310 feet.
okay.
Yes, 300.
So it's quite a distance to the closest residential building. It's not gonna be a residential building closer,
Correct.
so.
And you can't see it through the
I
fence.
don't
I'm
think
just-
You
there's
can't see it
not,
through the
there's not a
fence that's
direct
around the
sight
dumpster
line.
and the
Well, the
gas
fence
station
could
lot.
go, yeah, I'm just stating, it's a ways away.
Yes.
And I don't think there's a direct sight line
No.
from any of the residential buildings
Nope.
to the sign.
There isn't.
And it is a single-face sign oriented toward Mast Road, so you would only see the back and side of it anyway. even if they could see it from the residential areas.
We do have your responses to the variance criteria on the record in paper.
Yes.
Is there anything you want to say about them to elaborate?
No.
Board have any more questions? Questions?
No.
Jason?
No.
Alan? Denise? Okay, then we'll open the hearing to the public, which is nobody. So we'll close the public hearing and the board will enter deliberations.
I don't have any problems with it. I'll motion to approve.
I'll second.
Findings?
Sure. It's not contrary to the public interest. There's already a sign there. It's only going to be lit up. It's facing Mass Road, not interfering with residential. The spirit of the ordinance is observed. It is in a commercial district, only having an effect on the commercial. It's not going to do substantial justice for the same reasons I've already mentioned. The value of the surrounding properties will not be diminished because they're all in commercial. Any place that can see the sign is zoned commercial. No fair and substantial relationship exists between the general public purposes, basically for all the same reasons.
Okay.
It's a commercial district.
There would be no change to the sign other than the light.
Right. Thank you.
Thank you. I'll still second.
Okay. All right, then all in favor?
Aye.
Any against or abstaining? Motion carries.
Thank you all.
Have a good night.
Thank you for your patience.
No problem.
We should serve coffee. This meeting is getting long.
Can we make a motion for that?
Can you like?
Make a
I've
motion
seen
for
it,
that?
I've
Put it in
seen
your
it
budget.
11 o'clock once.
Judy, you don't know long.
Okay, in our correspondence, we had the request for the rehearing of the rehearing of the ZBA denial of an appeal. That would be the,
The signs.
The guru.
oh, that's right.
Yeah.
Okay. My mind was going to the Hemley application.
Okay.
Okay, so we have that request for rehearing, so we should address that.
I just have a quick question.
What?
Derek, did they submit a variance request?
They have not submitted a variance request.
Okay.
However, I just want to caution this board, and it almost came up with this, the Hemley application. If somebody is appealing a decision, they're saying that decision was wrong, not that I should have got a variance. I think that you need to be careful. Variance is a relief from zoning. An administrative appeal is the board or officer that interpreted interpreted the zoning ordinance did it wrong. They made a mistake. So, and my recollection was he was appealing a decision on a sign permit not granted. He always had the option to seek a variance.
Right. I just
So,
wanted to
so
know
I
if it
just,
had
I
been
just
done.
wanna caution you on that, that if you, that shouldn't factor in whether or not to grant a rehearing. It should really be anything that he brought up in his rehearing request.
I didn't see anything new in there. I saw almost the exact rehash of what we went through last night.
Okay.
And I will say, even though I wasn't here for the last meeting, I spent quite a bit of time reading the minutes in detail, and after reading that and reading the request for rehearing, it's plowing all of the same ground. You know, it doesn't apply because, and to be frank, I don't think he is looking for relief in the correct venue. You know, he's asking us to make a constitutional decision, and I don't believe we're a land use board. We're not a constitutional tribunal, and
I believe
don't
that,
see a reason to grant a
right, staff was
rehearing.
following the ordinances we have. He chose to go that route, and I don't have an issue with what staff did. Stand by
I
that.
think everybody should read 3.8, which is called nuisances and hazards from the zoning ordinance. And he does have a cause here.
I don't disagree. I read your
So-
correspondence
Yeah,
on
but
it,
this
Alan,
isn't
and
the, that's
What
not the
was
right
that?
venue.
That's
you got a hum, but this
What?
is
Three-
the
3.8.
proper form to address.
3.8 on page 27. He can actually make a complaint under the zoning ordinance.
Right, but it's
About
not
the
our job to
accessibility.
make that
It's not our
suggestion.
job to do it.
Correct.
Right.
So he has avenues, but I saw nothing new in his submittal for a rehearing.
Do we have a motion? Or do you want to still discuss? I mean, it seems like
I'll
the consensus.
I'll move that the request for a rehearing be denied on the grounds that he has not presented any new evidence to support his arguments.
Second.
Okay. All in favor?
Aye.
Aye.
Aye. Any against or abstaining? Motion carries. Okay, we have before us, we do have the schedule for 2023's zoning board meetings. And I think they look okay, but we should probably look
They
at
just
them.
tweaked it, right?
The only one that does not fall on the first Tuesday is Tuesday, July 11th. So that would
Thank
be
you
the-
for that.
Yes. Yeah.
When's town voting day in 2023?
So the actual ballot day, where we go to the polls, or the deliberative session?
Both.
So the deliberative session, I do need to confirm, you may wish to move the February meeting, because we typically do hold deliberative session, I don't know if it's on Monday or Tuesday night of that week, either the 6th or the 7th. I will have to confirm with Danielle. If the deliberative session is scheduled for the 7th, which it may well be, do you wish to move that to the following week?
Yes.
I would say yes. Sorry, dear.
I want to say, when I looked at some correspondence that crossed my path, both the budget committee and the town's public hearings were on a Tuesday with the alternate snow date of a Thursday.
Oh, I've got it here. Okay, I can answer that now. Right now, this still requires select board approval, but staff is going to be making the recommendation that we hold the deliberative session for the town on the evening of February 7th. So
Okay.
I would suggest you move that meeting to February 14th.
Okay,
Valentine's Day.
It is.
that's okay.
And if your Valentine is a resident and would like to volunteer, we can get them on the board and they can see them appropriately.
They can take my place.
Is the board okay with making that change?
Yep.
Everybody's okay with making that change?
We need another 4 alternates, but
They're gonna all quit.
And we also have the proposed zoning amendments changes from the planning board. There's a copy in here someplace. There's not too many of them. They are proposing to take away the one where they have to comment, they're offered to comment to us.
Yes, I saw that.
So they are taking that one away.
Pleased to see that.
They are removing all references to residential use in the commercial industrial flex
Not
zone.
happy about that. I'm not, can I tell you, not just for myself, because I'm probably, 99% chance I'd never put residential. That's not the point. There's a reason that that zone was created. It's been abused, but it's been allowed to be abused. And I don't agree that they changed the zoning because people have been allowed to abuse it.
Well, let me find myself, it's very odd that Denise and I find ourselves on opposite sides of this question, because I do agree that it has been abused, and I think removing it from the commercial industrial flex would help to preserve more of the commercially developable land that we have along 114, particularly, I mean, our development corridor is basically the 114
I agree.
corridor, and I think we need to do with zoning what we can to preserve that for commercial development. So I think removing the residential component is a
You
good
need to look
idea.
at the size of some of those lots and how deep they go. In a good, is it Kennedy Road? That's a class 6 road?
Yes.
Goes up the hill?
Yeah. The one that, there's a couple residential houses we've given.
Yeah.
That's all CIFZ. So now, the only thing that can go in there, way in the back, is commercial or industrial with this zoning. So there's more to it than them putting apartments on, or whatever, on Mass Road. Some of these lots are deep, and that's why they created that zone. I just think it was abused close up, which is where you want the commercial.
And unfortunately, I think the abuse close up is likely to continue, which is why
Well, they
I
have to
think
get it,
removing
they have
it
to
is a
come to
good
zoning.
idea.
Go through planning.
Well, that's a
You
good
know.
point, Denise. I mean,
But that's just my opinion.
but I mean, if that was, the way to fix that would be to change the allowable residential use in that to the back portions of those lots.
Or change the zone.
Difficult to do.
So change, instead of changing the zone types, change the zone assignments?
It's just, if you had a piece of property and you could do this, and then they changed it, I don't think some people would be very pleased. I don't know what, their rights are good. Again, I don't
No, I think
see
that's
myself,
happened too.
I don't see myself doing anything, so this isn't about me, but there are some deep lots.
Well, I think it takes away the potential for the Housing Appeals Board to come up with a decision like they did with the previous application.
Yeah, but that's not the only one that was abused.
No, it's not.
No.
And what
Some
I-
of them are abused with thumbs up from this board.
Although I don't see.
You talking about me?
I wasn't there, I wasn't on it,
Me
on that
neither.
side.
But I
But-
just,
But the thing is, to be quite honest with you, all right? On that one lot that we got variances across from the villa, right?
Mhm.
We tried for a year and a half to do a commercial development there. And had not one single person come back to us, a company come back to us and say, can we take a look at it?
You know what, I could say the same thing, I'm not asking for a variance, it's about being patient. The land will be used for commercial because that's all we have in town, unless it's developed residential. That's not a mixed development there, that's strictly housing.
Right?
And it does sit by itself, I'll give them that, I will give them that, but I didn't create these districts. You know,
Well,
but-
it's, if you took into account the 380 acres that the county has.
Oh, no, let's not go down that.
And try to get them to, they have a master plan, because went there, and worked on it, to develop those
They
properties.
own the
We're not
most
gonna
valuable
solve, we're not gonna
property.
solve the town zoning issues tonight.
Why not?
So let's stop the discussion and have a motion to adjourn.
Motion to adjourn.
Any second?
second,
All in favor?
No seconds, dude.
Aye.
Everybody wants to stay here.
I oppose.
Yeah, same
You can
here.
stay.
For once, I've opposed
Three of
something.
us are in favor, so motion carries.
Yeah, thank goodness.